Good afternoon. I'm Christine Lowe, Program Co-Chair for the League of Women Voters of Greenwich. The League of Women Voters is a membership organization which works to empower voters. We envision a democracy where every person has the desire, the right, the knowledge, and the ability to participate. On behalf of the League, I'd like to welcome you to a webinar discussion with Marissa Gillett, Chairman of the Public Utilities Regulatory Authority of Connecticut, or PURA. PURA is charged with ensuring that Connecticut's investor-owned utilities, including electric, natural gas, water, and telecommunications companies, provide safe, clean, reliable, and affordable utility service and infrastructure. PURA's mission is essential to advancing the state's energy, economic, and environmental goals, and is critical to maintaining public health and safety, as well as a robust economy. In the context of recently announced utility rate increases, the tremendous amount of utility infrastructure work, including tree maintenance in town, the advancement of alternative energy technologies, and other factors influencing utility supply and demand, we believe that it is more important than ever that the citizens of Greenwich understand the role of PURA, how it interacts with a community and the companies it regulates, and how we can participate in the conversation. Marissa Gillett has been chair of PURA since 2019. Before that, she was Vice President of External Relations for the Energy Storage Association, the National Trade Association, representing the energy storage industry. Prior to that, she worked at the Maryland Public Service Commission, an independent agency within Maryland state government that regulates public utilities. Ms. Gillett received a Bachelor of Science in Bioengineering from Clemson and a JD from the University of Baltimore School of Law. Today's session will consist of a 40-minute overview presentation by Marissa, followed by a 15-minute Q&A session. Audience questions can be submitted by the Q&A link during the presentation. Christina Broderick, my League of Women Voters co-chair, and I will pose the questions to Ms. Gillett after following her remarks. Before we hand the presentation over to Marissa, I'd like to welcome Steve Meskers, our state representative from the 151st District, who serves on the Connecticut State Energy and Technology Committee and is chair of the Commerce Committee, to provide some introductory comments.
Thank you, Christine. I want to welcome all of you to this Zoom meeting. I've had the pleasure of serving on the Energy and Technology Committee for the last, I believe, the last 4 years. And I have to say that, you know, having worked on Wall Street, having worked in the investment banking, having looked at the opportunity space in energy, and having looked at the regulatory framework, it's amazing how complicated, how difficult, how structurally the impediments are to getting it right. Working with Marissa Gillett has done nothing but affirm the idea of the right people in the right place can make a huge difference. I've sat with her, and I can tell you it's important when you go and after you've worked in banking at a pretty high level in the international side, you don't want to be the smartest person in the room. And every time I sit with Marissa, I'm reminded I'm not the smartest person in the room. The conversation, the thought process, the way, the ability she brings to the table is impressive. The issues that we're dealing with are not issues of her making, but issues of structural impediments and structural problems in the energy market in New England and specifically in Connecticut. And I can tell you in the time I've worked with her, she's worked diligently to try to reform those markets and try to bring what I would say is a regulatory overview and sanity to that market. So without further ado, it is my great pleasure to introduce Marissa Gillett.
Thank you very much, Representative Meskers. I really appreciate those opening remarks. It's really been a pleasure to work with you over the past couple of years in my tenure, and I know we both know there's so much more work to do. So looking forward to engaging the crowd this morning, or this afternoon rather, to explain how you can get involved and to help Representative Meskers and I continue to move the ball forward here. I also really want to thank Ms. Broderick and Ms. Lowe, the co-chairs of the League of Women Voters in Greenwich, for this invitation, as well as the Greenwich Tree Conservancy, who we've had the opportunity to interact with on a number of PURA dockets. So we will have time for Q&A this morning. I'm sorry, it's this afternoon. We will have time for Q&A this afternoon. We do have a prepared presentation that I hope will address some of the questions that we know to expect this afternoon, and happy to address many more questions in the time remaining. So the purpose of this presentation, and if you've seen me give a variation of this presentation before, the real purpose is to explain what PURA is and what we're not, and also how to engage with us and a few of the topics that we cover on a day-to-day basis, and how those affect your daily life and how you can affect the outcome of those proceedings. I do want to take a minute at the end of the presentation to focus in on what is the hot topic of today, the generation rates that have been announced to go into effect January 1st of next year. So I will cover that as well as what you might be able to do about that before the close of this presentation. So I'm going to start here. There are a lot of words on this slide, and we're happy to make this presentation and the recording available through our co-host today. But really what this slide is explaining what PURA is and a little bit about the subjects that we regulate. So PURA, in my experience, which is the shorthand for Public Utilities Regulatory Authority, every state has a PURA, as you heard in the opening statement. One of my previous roles before this position was serving as staff at the equivalent agency in Maryland. So every state in the country and most countries in the world have their own version of PURA. They're sometimes called public service commissions. In Massachusetts, it's the Department of Public Utilities, but we all have the equivalent of PURA. And the reason is because 100+ years ago, when electricity was coming to the forefront, there was an understanding that the energy world generally, whether we're talking about electricity, natural gas, water, each of those industries to varying degrees is a natural monopoly, meaning that especially when it comes to the infrastructure, so the poles and wires for electricity, the pipes in the ground for the gas or the water, it's not practical or cost effective to have multiple providers filling that role of the distribution partner. So because these are natural monopolies and there's no market to check the profit that they're making or to ensure that they're making adequate investments in the infrastructure, the concept of regulatory commissions came about. And that's where we trace our roots back to in Connecticut. And we're statutorily responsible for serving as what the competitive market would otherwise bring here. So we're talking about investor-owned utilities, and this distinction is really important. If you're served by a water company in your area that is not owned by investors, we don't regulate them. So if you're served by an electric provider, in parts of the state, there are municipal providers or cooperatively owned, we don't regulate them. We're talking about the investor-owned utilities such as Eversource, United Illuminating, their gas affiliates, so Southern Connecticut Natural Gas, Yankee. And then on the water side, it's a smaller percentage of the state. We're talking Aquarion, Connecticut Water, and just a handful of other investor-owned utilities. So what do we do on a day-to-day basis? What does it mean to regulate these utilities? It can mean a number of things. And what it means to me in the state of Connecticut is different than what it means to a regulator in another state. Historically, regulators think of themselves as economic regulators, Monday morning quarterbacks who are looking backwards at the investments that these utilities have made and assessing whether those investments were prudent and reasonable, which are legal terms of art. But in Connecticut, over the past couple of years of my tenure, we've been trying to turn this on its head a little bit and get more involved in the upfront planning and direction that we're going with these utilities, particularly as the state takes on more aggressive decarbonization goals and a heavier reliance on these day-to-day utilities, whether it was because of COVID and more people are working from home, or just the general trend towards electrification, which is, of course, going to put more stress on our electric grid. So besides regulating their distribution rates, and I want to emphasize distribution, and I'll come back to that later, there are other things that we do on a day-to-day basis, such as putting together programs that these utilities are going to run. We started reviewing their customer outreach materials. We look over acquisitions that they make, particularly the water companies, are starting to buy up smaller water systems. We also have responsibility for the safety of natural gas pipelines in the state, which involves a lot of on-the-ground inspections and enforcement actions. That keeps us busy on a day-to-day basis. But sometimes it's easier to talk about what we don't regulate, and this hopefully will address a few questions up front. So some of the activities that we don't regulate, one of the #1 questions we get is, can you help us with our internet bill, the price or the terms, et cetera? There are a lot of complaints that come into us on a daily basis regarding the quality of service of some of these internet and cable providers. Unfortunately, we do not regulate the prices or terms of the internet and cable industries. And you may be thinking back a couple of moments ago about, well, I thought you said you regulated investor-owned utilities. We do in the electric, natural gas, and water space. But a couple of decades ago, nationwide, the decision was made that the cable and internet industries, well, the internet didn't exist at the time, but that there was adequate competition in those services. And as such, because it was deemed that there was adequate competition, the ability of state regulators to reach in and regulate the prices and terms that these cable, now internet providers are charging was removed. So we still maintain regulatory contacts at those companies. So if you ever have difficulty getting a hold of a live person, for example, I'll provide our contact information later in this slide deck. But when it comes to the price and the terms that they're offering, that's unfortunately out of our jurisdiction. Few other things on here, timely information. We don't regulate heating oil companies or propane. So again, those are industries where there was, it was deemed that there's adequate competition. They're not monopoly providers. So those kinds of things fall outside of our jurisdiction, as do a number of the other items on this screen. I'd like to spend a moment on this slide because I think it really puts a fine point on the next couple of points that I'd like to cover with respect to what PURA is and what we're not. So I think that PURA is one of the most misunderstood agencies. In fact, prior to a couple of years ago, my guess is you didn't even know what PURA is or that an agency like us existed. But if you are familiar with other state agencies, you may be familiar with the concept of it being led by a commissioner or a secretary, someone that is brought on by the governor and is leading a state agency. That's not the case for PURA in the sense that we're not led by one individual. So I have 2 colleagues, so there's 3 commissioners. I do have the title of chairman. That means that I get to set the agenda largely, the staff report to me. But when it comes to a decision that has to be made, we operate a lot like an appellate court, where it's a majority decision. So over the past couple of years, you may have seen I've dissented a few times, but the decision is still legally binding. That's because we operate like a court, where it's not one of us making any final decision. So I like to draw that distinction here too, because it gives me an opportunity to explain how we do our work and how that work is different than other state agencies. So as I mentioned a moment ago, we operate like a court. So you'll sometimes hear us described as a quasi-judicial agency. Quasi is not, so we're not a quasi-public in the way that Green Bank might be. We are still an executive branch agency, but we are quasi-judicial, meaning that our operations are kind of a blend of the executive branch and the judiciary. So, so if you think about having to appear, if any of you on the Zoom are lawyers, if you've ever had to appear in appellate court, for example, particularly for a civil matter, a lot of the way that PURA operates might be familiar to you because we operate just like a court, where myself and the 2 commissioners are operating as judges. So I get asked a lot, well, aren't you the consumer advocate? Like, what's going on here? And the answer is no, I am not the consumer advocate. I am the judge of the situation. So we do in fact have a consumer advocate, the Office of Consumer Counsel, who is a statutory party in our proceedings, along with a few other statutory parties, including the Department of Energy and Environmental Protection. So when a matter is brought to our attention, you may be wondering, okay, what does it mean if you're operating like a court? How do you reach a decision on a matter? The answer is through a process called a docket. It's a synonym for a case or an investigation. It is a self-contained record where we have been asked to we've either been directed by the legislature to take up a matter because we are a creature of statute, or I have decided that we need to take up a matter, or we've been asked to take up a matter by a utility or a party or intervener. That will initiate a docket. And that request needs to be made within the context of our statutory powers. So if the request comes into us and it's asking us to investigate the prices of the heating oil companies, for example, we would not be able to initiate that docket as we do not regulate them. But if the matter is coming into us and asks us a question or to investigate something within our oversight, we will initiate that docket, and then we will commence developing a record. So again, back to the court analogy, we are developing a body of evidence, and that can be developed in a couple of different ways, through technical meetings, written comments. Interrogatories is just a formal word for questions that we or other parties will direct to the proponent of the action. And then we can move towards, sometimes we'll have evidentiary hearings, which again look very much like a court proceeding where you have witnesses, you have parties cross-examining those witnesses, and myself and my colleagues can ask questions. And all of that leads to PURA issuing a draft decision on the matter. That draft decision is usually issued by the lead commissioner, so myself in this situation. And then we'll seek written exceptions, which are comments on that decision. And sometimes we'll offer oral arguments where the attorneys for the parties and interveners in the matter can tell us why they think we got the decision wrong. All of that leads up to a final decision. And again, any decision that PURA makes has to be approved by a majority of the commissioners. And we vote publicly on those decisions at Wednesday morning regular meetings at 10 a.m. So what I'd like to say about this whole process is that all of it is public. I've been here for a little over 3 years now. And in that time, we have had exactly 3 confidential sessions. And in the course of a year, we have anywhere between 80 and 100 active dockets at any given time. So 99.9% of the work we do, you can monitor us on Zoom. We now live stream our hearings on YouTube. So really the purpose of this is that we're trying to increase the transparency into what we're doing on a day-to-day basis. The other thing I like to stop and pause on here, now that I've talked you through how similar to a court action this is that we do, again, for anyone who's familiar with the court system, you know that a decision has to be made based on the evidence in the record. So I don't want to oversimplify this, but for example, if the question is posed to PURA, is the sky blue? And we have an investigation into whether the sky is blue. If no party tells us and provides us evidence in that proceeding that the sky is in fact blue, it does not matter that I know the sky is blue. I cannot make a decision finding that the sky is blue without substantial evidence in the record. So I want to harp on that a little bit more because it is the precursor to why I hope to convince folks like yourselves through these presentations about why it's so important to pay attention to what PURA is doing and engage in our processes, because it's really crucial that we get in different perspectives and a wider variety of evidence so that we can make decisions that expose us to all those different types of evidence. So I've covered a couple of these things on the screen so far, but I do want to use this opportunity to say a few more words about it. You know, we are akin to a court, as I've been repeatedly saying, which means that decisions we make are legally binding on the utilities that we regulate. It also means that those parties have statutory due process rights, which allow them to appeal our decisions to the Superior Court. And they have been in a number of cases recently. It also ensures due process rights for folks like yourselves. It's not just about the utilities. So one of those rights is our Exparte Rules, which again, if you're familiar with the court system or you've watched Law and Order, Harry Mason, something like that, you may recall scenes where a judge will call the attorney back into his or her courtroom chambers, and they insist on having the other attorney there. That is the same situation the rules that we abide by. So what I mean by that is I cannot engage in a substantive conversation with anyone about any topic that I have pending before me, unless that conversation is happening in my courtroom, whether the courtroom is virtual on Zoom, or we've been having moving back to the in-person hearing room. But that means that I'm not behind closed doors with Eversource. It also means I can't be behind closed doors or in a Zoom room with you all and discussing or speculating about a decision that I might make. So when we get to the Q&A section, I'm sure there will be a number of questions touching on topics that I have pending before me. And that way I can provide a procedural update about what we are currently doing. I'm not able to speculate about what I might do. So that is a key point. Excuse me. So hopefully at this point I've convinced you why it's important to engage with PURA. Again, because if you're seeing decisions that are lopsided, one of the key drivers is that we do not have enough evidence in the record that has led us to reach a different decision. So it's important to engage with us as much as you can on as many topics as you can. And that engagement needs to be providing evidence. So I'll get back to that in just a second. But the next two slides can cover a spectrum of ways in which you can engage with us depending on your interest level and your availability. So again, everything that we do is public. Our website has, you can access the materials any time of the day. And we maintain an online calendar of all the dockets that we have open. So one thing that you can do is sign up for notifications with respect to any docket that you're interested in. Now, as I mentioned a few minutes ago, at any given time, we may have between 80 and 100 pending dockets before us. So we don't expect you to navigate or sign up for notifications for all of those dockets. In fact, many of them may not apply to you, as they may be pertaining to utilities that don't serve your service territory. What we have recently started doing, we launched our first quarterly newsletter a few months back, which is a consolidated couple-page newsletter that provides information about key decisions we made in the past quarter, and also lists all of the public-facing actions that we have in dockets for the next quarter. So our next iteration of that newsletter is scheduled to come out in January. And I would highly advise checking that out, finding the docket number of any matter that is of importance to you, and signing up for notifications. If you have time and interest, and that outcome of that proceeding really is meaningful to you, then there's a couple of more active ways that you can engage. The first one on this slide speaks to providing comment on the matter. So depending on the type of docket that we have, we may have a separate public comment hearing. We also offer public comment opportunities at our evidentiary hearings or technical meetings. You can sign up to provide comment live verbally at one of those meetings. or you can provide comments in writing into the record by email to the address shown on the screen here. So the good news is that comments provided verbally or in writing are given equivalent evidentiary weight. So it's really up to your personal preference as to whether you'd like to provide the comments live or in writing. And then the final bullet on the screen is really, recognizing that this may be out of reach for a lot of individuals. I still like to include this as we've had some really meaningful participation in this way over a couple of key dockets over the past couple of years. If you have the resources to, you can formally intervene in a docketed matter. We have tried to address barriers to our proceedings in which you're not necessarily required to be represented by an attorney. Of course, since we still are operating very much like the judiciary, attorneys can help with that process. But we've had some really great examples of groups or towns, municipalities intervening in docketed matters over the past couple of years. And the benefit of that is that they can then introduce their own witnesses, they can introduce their own evidence, they can cross-examine the utilities, they can file legal briefs. So there's a lot of legal rights that come with formal intervention in a matter. So this slide shows what it might look like for you if you want to understand a little bit more about a specific docket. So on this slide is a couple of screenshots. If you want to learn more about how to access our materials. Again, everything we do is by docket number. So once you've located your docket number, you can actually access all the materials that are filed in that docket. So at any given time, you can log in, you can read the legal briefs that have been submitted by parties, the correspondence, you can see the interrogatories, so the formal discovery questions we've issued and their answers. So that material is available at any time of the day. And I do want to stop on this example for a moment to really explain how meaningful it can be to provide public comment or to intervene in a matter. Because I often get, it's healthy to be skeptical, right? And certainly when I try to convince people to participate in our dockets, I get the common refrain, well, nobody reads that anyway. And so I like to go back to this example from last year, which I think is illustrative of the fact that providing public comment and formally intervening in a matter can be very meaningful. And these are screenshots of PURA's decision in our investigation into Eversource and UI's response to Tropical Storm Isaias. And just quick screenshot excerpts of what was a couple 100-page decision. But in these quick screenshots, you can see we go through, we summarize all of the public comments that we received. And also in this proceeding, we had several municipalities who banded together their resources, hired attorneys, and several first selectmen and first select women were actually witnesses in this proceeding. And I can say without a doubt that the evidence that they provided, as well as the cross-examination that they did of the utilities, directly led to the result of that proceeding, which was that we fined Eversource $28.4 million for their preparation and response to, or their lack thereof, to the tropical storm. And at the time, that was the maximum civil penalty that could be levied under the law. And I would personally directly attribute a lot of that result to the evidence that was submitted to us by individuals, as well as by the first selectmen and women that were actually witnesses in that proceeding. So the last topic, again, that I wanted to cover during the formal presentation, I'll open it up to comments, which I see several coming in, is that I want to just pause a moment on your monthly electric bill, and then also talk about third-party suppliers and the generation rates that we're going to see. So this screenshot may remind you of your monthly electric bill that you receive from Eversource. And the number one question that I used to get, I think it's been supplanted a little bit by more recent events, was why is my delivery charge 3 times my supply charge? And so I used to use this slide to, and the next one here to explain the components of delivery versus supply. We have recently completed a docket that will lead to the redesign of these electric bills. They'll provide more insight into the cost drivers of each component of your bill, because the answer to that question, why is my delivery 3 times the rate of my supply, is it's actually not, because your delivery has been, the delivery portion of your bill has been used to comprise what are really 3 different categories of charges. And I think it was an oversimplification made a number of years ago to describe it just as supply versus delivery. What your delivery side of your bill actually incorporates are 3 different categories: transmission, distribution, and public policy programs. The transmission, we get a lot of the question. Another question we get is, why do I have to pay for both transmission and distribution? And I'd like to start by trying to draw the analogy to our transportation system, roads in general. So if you don't know the difference between transmission and distribution, the best way I've been able to describe it is transmission is akin to like highways, where you're going at high speeds, or in this case, high voltages, across long distances, across state lines. It's regulated by the federal government because we're crossing state lines. And that can be upwards of 15 to 20% of your bill these days. That is different than the distribution portion of the infrastructure, which is what we regulate and is controlled by Eversource and UI in this state. It's around 35 to 40% of your bill. And the distribution system is more akin to the roads outside of your window. It's where, the speeds, or in the case of electricity, the voltage has stepped down and it's going at, lower rates to the end users. So it's 2 different pieces of infrastructure, one crossing state lines and one at the local level that's actually delivering the electricity. Also 2 different regulators, one at the federal government and one at the state government. And then finally, the public policy programs, which are generally programs that have been, discussed and adopted by the legislature, or otherwise deal with the delivery of electricity. So backing up just a moment to supply, and this is where I want to hover for a moment. Supply rates are generally changed January 1st and July 1st. Historically speaking, the supply rates, which are also called standard service, go up on January 1 and they come down on July 1. And that's because we're tied to the regional markets, and it's generally cheaper to produce electricity in the second half of the year than it is in the first half of the year. And let me really emphasize the role of the markets here. So you just heard me give a lengthy presentation and talk about distribution infrastructure and my ability to set rates for distribution infrastructure. I do not have those same tools in my toolkit when it comes to supply or generation. About 2 decades ago, the decision was made to deregulate the generation portion of your electricity bills because the decision was made that there could be adequate competition for who would generate the electricity. So at that time, Eversource and UI were ordered to divest ownership of their generation assets, and instead they are tasked with providing a product called standard service, which is they literally go out to the market and they procure the most competitive way that they can generation supply to serve their customers. And it is a pass-through cost on which they cannot earn any profit. So you may think, okay, well, what did we get in return? The idea here was that deregulation of the supply industry, the generation industry, would allow adequate competition so that customers could choose to go with a different provider if you wanted to. So, 85% of customers, residential customers, that is in Connecticut, have typically used the standard service product. And the other 15% have been shopping for a third-party supplier. So what does that mean? There is a website that the state oversees called Energizedcom. And you can go to that now after the presentation. And on this page, you can literally shop for your provider of the generation rates. And there is a rate board. So on this screen, you can see in the middle, it says Supplier Rate Finder. That will take you to the rate board where you can input your information. So you can say, I use approximately 1,000 kilowatt hours a month. I live in the Eversource territory. I'm looking for a residential rate. And it will populate the offerings available to you. So if you go today, you may see a number of providers that have a rate that is lower than what the standard service rate will be on January 1. So it is your right, and in fact, I have done this personally, to go shop for a third-party supplier and lock in a rate that is going to be lower than standard service. So there are a couple of cautions that I would offer here. You know, I get the question, I've gotten the question a lot in the past couple of weeks. You know, what can I do about the coming spike in generation rates? And the answer is you can go shop for a third-party supplier. And then I get the question, well, how come folks haven't been shopping historically? Well, the answer is that the standard service rate has historically been a competitive rate, been more competitive than the third-party suppliers have been able to provide. That's not going to be true these next 6 to 12 months. So I would encourage you to go check out the rates that you can and see if you can save compared to the standard service rate, which is going to be in the 24-cent range come January 1. Now, the caution here is this is not a set it and forget it practice. It is something that you are going to want to put into your calendar 45 days in advance of July 1, 45 days in advance of December 31st. You are going to want to make yourself a reminder to go back to the rate board and make sure that the rate that you have is competitive compared to the announced standard service rate. Because again, those rates change every January 1 and July 1. And this is also very important. If you go to that rate board now, you'll see some folks advertising a 2-year rate, a 3-year rate, sign up now and lock it in. So because of legislation that Representative Meskers championed 2 years ago, those suppliers are no longer able to charge an early termination fee. Let me say that again, they may be advertising a 2-year or 3-year rate. If you exit from that rate before the end of the term because you're moving, because you found a better rate, because standard service is going to be cheaper, that is your right, and they can do nothing about it in terms of an early termination fee. So I really want to make that plug. Representative Meskers has been a champion of making sure that consumer protections in this market are increasing because there's a lot of consumer protection issues that can arise here because there is no prohibition on these companies auto-renewing your rates at a higher rate than you were initially authorized. So that's where you need to be cognizant of is before the end of that term, you need to go in and make sure that the rate that they're offering you is still competitive compared to utility standard service or another supplier. So again, please do it, but do not set it and forget it, because at some point the standard service rate will become more competitive and you do not want to be locked in, and you legally cannot be locked into a rate that is higher in auto renews. So hopefully that provides you with a tool to walk away from today. We do have a division of my staff that is dedicated to enforcing some of the consumer protection issues that we've had in that market. There have been a number. So I want to make sure that folks don't walk away thinking that that is a panacea. It is a tool that you can use at the moment, and I would encourage you to do so. Okay, the last thing I want to leave you with is the numbers and contact information for PURA, and then I'll open it up to questions. We do have a customer services division. I don't want to oversell this. PURA as a state agency has 75 people, including myself. So we have a small division of my staff that man the phones, and the customer services division is available to assist with questions you might have about a utility service. They can help you navigate disputes that you may have over your specific bill with a specific supplier or utility, and they can answer questions. So the phone number is toll free. You can email, you can also file a complaint using our online form. We will do our best to resolve that. If you have a more far-reaching concern, so a policy issue, for example, that's not what our customer services division is. I really want to point folks here if they have an individual concern, question or dispute that you'd like assistance with. So with that, thank you for joining us. Again, thank the Greenwich Tree Conservancy and the League of Women Voters for having me, and I will turn it over to our co-hosts to moderate the questions.
Fantastic, Chairman Gillett. Thank you so much for that incredibly informative presentation. There's a lot to go with there. Really appreciate that. I do see, before I jump into the first question, I saw that Representative Meskers had his hand up. So I just wanted to let him speak real fast.
Yeah, I want to thank Chair Gillett for her commentary. And I want to emphasize, in the past, I have not been a big fan of third-party energy suppliers. The issue is arising with an opportunity space because of legislation. The problem with third-party energy supply bills is they get to be sticky, which is why the chair was talking about the rollover dates. If you leave your bill on auto-renew, I can virtually assure you that you will be paying a premium to the average service contract in the future. So you need to be a proactive shopper. In the past, on the regulatory side, we've seen, I think, close to $7 million in the energy assistance market as surcharges. I think the general market, we were somewhere around 35 million in the average surcharge on third party. So this is an opportunity that I think is very unique. And I want to caution people, if we migrate from 85% in the general product down to 70, and now we end up with 30% in the third party, I would pray that on the rollover dates, they're on their game and don't end up paying a premium. So that's, I think the chair mentioned it. I just wanted to emphasize that. And thank you.
I'm going to go ahead and jump into some of the questions that are coming in through the Q&A. And then we had some other questions that were submitted in advance that, we will try and get to as well to make sure that we are hitting everyone's interest here. So I'm going to go ahead and read the first one. It's a little bit long, so bear with me. How can individual members of the public possibly balance the highly paid and professional staffs companies such as Eversource and UI have monitoring and arguing in front of PURA year-round? As a utility goes to an individual street in a small town, for example, take down 100 trees as they did in Darien, many members of the public don't have the expertise to engage effectively. And even if a town can organize to an extent, what happens when a first selectman is more concerned with getting on a utility's good side to make sure electricity is turned on after a storm and has no interest in disagreeing with the utility?
Excellent question. So I think there are really two separate, but obviously related points in there. So I'm going to take the broader question first about how do you engage in a productive and efficient manner with PURA when you're facing utilities and other organizations that are very well funded. So first, let me say, one of the things that's most disturbing to me and that I like to touch on is I think it's not very well known that almost everything a utility does comes back through your rates. So they are actually compensated to put on a rate case. They can recoup those rates, the cost of putting on a rate case and appearing before us through their rates. Representative Meskers and other leaders in the E&T committee actually passed through the Take Back Our Grid Act, what I would say is a first step at addressing that, which is for electric utilities, they are now prohibited by law from doing what I just said. So they cannot recoup the cost of putting on a rate case in front of us. But other types of utilities still can, and I think that's a loophole that I look forward to addressing with Representative Meskers and his colleagues. But when you get down to it, whether they are or are not collecting or recouping those costs and rates, they still have the expertise that is going to outmatch individual ratepayers on an everyday basis. So that is really why on the first instance, I'm doing presentations like this, because I want to reach individuals where they're at and let them know that it doesn't matter if you don't have the day-to-day expertise. Some of the evidence that was provided in the Tropical Storm Isaias investigation that we were able to rely on was something as simple as someone taking a photo and submitting it and saying, listen, they said my power was restored at 9 p.m. It wasn't restored until noon 2 days later. And here's a picture of trucks that were sitting over here when they should have been here. Like, these are things that don't require an accounting degree, an engineering degree to be able to submit meaningful evidence. And we don't work in the way that we don't need form letters. Like, we don't need to receive that comment 100 times for it to make a difference. We can lend the credibility to the evidence that we see fit as the decision makers. So that's one thing to do. The second thing that I look forward to pursuing with the ENT committee and the legislature is something called participant compensation. So you may see on the Capitol report today, or you can certainly Google it, there is a growing number of folks in other states that are pushing forward legislation that would compensate individuals for their participation in regulatory proceedings. So it's been done in California, Washington, the state of Washington, I think Michigan has it. Basically, these are regulations that allow groups of customers who can demonstrate a unique perspective that is not already covered by another intervener. And it will provide reimbursement or compensation for them to hire their own witness, to hire their own attorney. So that is something that I've definitely been discussing with my counterparts at the Office of Consumer Counsel today, and we look forward to exploring. On the more granular issue of the trees specifically, and I imagine this might come up in another question, how you address some of these more substantive specific issues really goes back to the statutory framework that we have to draw from. So when it comes to the trees issues, I think it's Connecticut General Statute 16-243 that outlines the framework about how we can engage and how customers do or don't have rights when it comes to trees. So some of these issues, and to address that question, the concerns of that commenter require a statutory fix that you may need to raise with your individual representative, because in that specific instance, it's the town and the abutting property owner who under statute has the legal rights to raise an objection. And again, since we're a creature of statute, we have to abide by the existing statutory framework. So I hope I touched on that question.
Okay, here's a question related to rates. Says that CNG said that the rate increase has to do with the increase of delivery charges. That is done by PURA. So in essence, they said that PURA was to blame for rate increases, and that's followed on by a related question. What can PURA do to control rate increases?
I appreciate the question. So whether we're talking about natural gas or electric, there are definitely some differences between the two industries, but there's enough similarities for me to answer this in one go, which is, so when it comes to the distribution infrastructure, that is what we're regulating. That's what we have control over when it comes to the rates that they're charging. On the electric side, that's about 35 to 40% of your bill. On the gas side, I don't have that percentage off the top of my head. But it's not your whole bill. So those rates are determined through what's called a rate case. And on the electric and gas side, they are supposed to file those every 4 years. And it's through that proceeding where we can go through that whole proceeding that I mentioned that you have evidentiary hearings, questions, and at the end of that proceeding, we will adjudicate the request for a rate increase. C&G and as well as Eversource have not been in for a rate case since my tenure began. And I really think that's problematic because there's a lot of the questions that I imagine folks have today for me, which is, can you control executive compensation for these utilities? Can you do this? A lot of those things have to, by law, be adjudicated through a rate case proceeding. You can't tackle them on one-off at a time because it's called single issue rate making, which is prohibited by US Supreme Court precedent. So I'd have to get a lot more into the weeds to understand what C&G has said. I definitely hear them, blame us for things from time to time, which are not accurate. But where we can really get into the weeds and start to unpack what they're charging on the distribution side is through a rate case, which they have not filed since I've been here. On the generation side, whether we're talking electric or gas, so there's a purchase gas adjustment charge, which is your pass through on the gas side, the fuel costs. Neither of those are regulated by PURA by law. So unfortunately, the answer as to what we can do to control those costs is negligible, and I can definitely unpack that as desired.
Great. We had a number of questions about utility poles and undergrounding power lines. So I'm going to try and consolidate some of them here, and maybe you can touch on where PURA has oversight for this and where maybe it's not with you. But first is there a plan for incremental undergrounding of the power lines? What can we do with double pole situations where there's just, multiple poles still just sitting there and, waiting to fall down? That's a maintenance thing. And I guess that's really it for, a number of the questions. But
Sure. So I'm going to take the pole issue first, and I'll head into the undergrounding because, as you mentioned, they are related. So poles have had issues in the state of Connecticut for, as best as I can tell from my research, at least 2 decades. There are different types of issues with poles. There are double poles, as you mentioned, Chris, that if folks aren't familiar with the term, means that there are poles right next to each other where they're in some state of transition from moving the wires from one pole to the other, or sometimes even the pole is now a bare double pole and has not been pulled by the owner. There are also structurally compromised poles where the pole looks dangerous, as if it has been struck by lightning or a car and it's strapped to another pole. There are also issues with what are called pole attachments, where some of the competitive providers of internet cable services aren't able to get onto the pole fast enough because the pole custodian has blocked access. Those are the 3 buckets of issues with poles that I have uncovered since I've been here, and we decided to tackle them through 3 dockets. The good news is I've finished 2 of those dockets, and I just issued a draft decision on the 3rd docket 2 days ago. So there is now a process in place for pole attachments to speed that up and to find the pole custodians when they don't. The structurally compromised pole process went into effect in May, which if a customer or utility or whomever identifies a pole that looks structurally compromised, they can call to the utility, they can call my customer service and flag that pole. And the utility, the pole owner, then has 10 days to rectify the situation, or they take on the financial liability. So in that 10 days, they have to send somebody out and to inspect it and certify that that pole is compliant with National Electric Safety Code rules. If it's not, they have to pull that pole and replace it. And if they do neither of those things, or if they certify it and it turns out to fall down during a blue sky day, they are financially liable for what comes after that. So that process went into effect in May. And then the 3rd docket on double poles, the draft decision I issued 2 days ago, institutes what's called a single visit transfer process and reinstates fines for when those polls are not pulled within the prescribed time period. So that decision is being voted on by the commissioners at our December 21st meeting. But I expect the combination of those three decisions and PURA's use of fines in the future to start putting some teeth into those decisions. Separately, you may think, okay, well, if we underground things, would that solve our poles issues and our tree issues? And the answer is complicated, of course. We do have another docket open that came out of the broadband legislation that requires us to look into a dig once policy. So if we do underground or DOT's doing some work or there's fiber being laid, we're looking into a policy and application process that would require all those entities to notify all the prospective providers so that they could underground everything in that situation once. So that docket is ongoing. A draft is due in January. But finally, on the question of undergrounding more generally, do we have a plan? The answer is yes. So we have an 11-part equitable modern grid initiative, which I founded in October of 2019, that looks at the 11 different ways that the electric grid needs to be modernized in order to meet our future goals. One of those deals with reliability and resilience, and that decision was finalized August 31st of this year. And part of that requires an undergrounding strategy to be developed, as well as some programs that go with that. And the working group product was filed with us a week ago. So that is under consideration by PURA right now. I think there was a motion asking us not to rule before December 16th, so some additional comments could be filed on it. But that will, of course, be a public document that we'll be able to socialize.
Okay, here's another one. The governor and DEEP have been working tirelessly to increase our tree canopy in the state, specifically in environmental justice areas. At the same time, Eversource has been clear-cutting trees using their ETT program, including long transportation corridors, which abut many environmental justice areas. Also, the town just received $38,000 in remediation costs from Eversource because they used pesticides near Greenwich Park against our town regulations and killed several town trees. Rates have been proposed to increase drastically, and these destructive vegetation management activities are passed on to the ratepayers. Will PURA demand Eversource's enhanced tree trimming subside, both to save much needed natural assets that aid in addressing climate change and assist in decreasing the rate?
Okay, great question. So the ETT program, or the Enhanced Tree Trimming Program, is not currently being collected in rates. So that is, the rates have not yet been passed on to customers for the last 2 years. This gets back to the question that I answered just a few moments ago about why it's so critical that these utilities come in for distribution rate cases, because the capital expenditures, including on expenses and O&M expenses on vegetation management, all of these come into consideration when they're in for a rate case. So I started the presentation today talking about how regulators typically view themselves, and I hinted at the fact that I view my role differently. So when I say that regulators are typically thought of as Monday morning quarterbacks, what I mean by that is the regulator is not managing the business of the utility. In fact, we are prohibited by law from micromanaging these utilities. That's actually the words of a legal decision. Rather, what we're charged with is looking at past expenditures and deeming them prudent and reasonable or imprudent and unreasonable. And those are legal standards that have developed over the course of a century plus, where you're judging the utility's actions by what a reasonable utility manager would have done at the time. So where that becomes problematic with things like vegetation management is that the current statutory construct does not empower PURA in the way that I think folks think we are. So we don't have the legal authority to send somebody out, nor do I have the staff to send somebody out and say, Eversource stop that cutting right now, because that's not actually what we're charged with. We're charged with, after the fact, evaluating whether the actions that they undertook conformed with, their things that they put in. Did they match their capital expenditure budget? Things like that. Now, when I explain things to people like this, they are obviously not satisfied with that answer, and they want to know, how can we change it so you're in the reverse? And the answer is, I'm trying. So through that equitable modern grid docket that I talked about, in particular the reliability and resilience framework, we are trying to get ahead of the curve by sending guidance that will have to be legally applicable on a going forward basis to these utilities by how PURA will evaluate the prudency of their actions. So if I can't tell them what to do, I can tell them how I will evaluate whether what they did was prudent and reasonable. And so there's a nuance there that I'm not sure I'm adequately communicating, but that is the route that we are trying to go, so that situations like the one that this commenter or question we're hinting at can kind of be flipped on its head, and we can get some more control or say so from the outset to make sure that the utilities are doing things that better conform to the long-term goals of the state.
Okay. I had heard that there was legislation put forward to limit new construction homes not to install systems that use natural gas or oil. Is this correct? And if so, what is the status of this? They had also previously asked about restricting oil to natural gas conversions.
Okay, so I'm not familiar with that legislation. If it was proposed last session, then I am pretty confident that was not adopted. But of course, we're about to go into another legislative session. Things like that, where we're talking about the policy of this state, are positions that are adopted by the Department of Energy and Environmental Protection in their commissioner and the administration. So if you would like to weigh in on whether those are actions that should be adopted, those are best posed to your representative, your senator, the Department of Energy and Environmental Protection, or DEEP for short, undergoes every 2 years a comprehensive energy strategy, where they do a wide survey of stakeholders and put together this document that speaks to the policies of the state moving forward. So as a creature of statute, PURA is tasked with implementing the policies or strategies that are adopted by the legislature and the administration. So if we're told, hey, you need to do X, Y, and Z, we will be tasked with implementing these rules and regulations, but we're not necessarily the ones making the decision on the underlying policy, if that makes sense.
Okay, we have a couple of questions about Eversource's acquisition of Aquarion, and why was that permitted to happen? And then also a question, why was Aquarion permitted to sell lands? Were they previously considered the public trust?
Okay, so Aquarion was acquired by Eversource in 2016 or 2017, I believe, which predates my tenure. So I'm unfortunately not able to speak to why the previous PURA authorized that. What I can say is that Aquarion is in for a rate case right now before us. We just had the evidentiary hearings the last 2 weeks. And as part of that proceeding, they are, of course, seeking the ability to recover the transaction costs associated with that merger. So that issue is pending before us, and I can't tell you, of course, what I want to do on that. But that is open. Whether, but the underlying question of why was Eversource allowed to buy Aquarion is something that predated me, and I'm not able to address, unfortunately.
Okay. How are Connecticut utility costs compared to other states, especially those in the vicinity of Connecticut? Is there a breakdown by energy providers, delivery costs, et cetera?
A great question. So most of the national comparisons that I'm familiar with are done on an all-in basis. Since states generally do their own thing in terms of what portion of the costs are recovered on a volumetric basis, meaning it's the rate times the number of kilowatt hours you use versus fixed charges. So typically the comparisons that you see from one state to another are done on an all-in basis where they have added in generation, delivery, public policy, anything that has been put through a customer's bill has been rolled up, and those comparisons are used. One thing that I would caution folks when they look at those comparisons is they can sometimes be misleading if you're looking at it on a per kilowatt hour basis versus a total bill basis, because different states, particularly if you're comparing different parts of the country, will use different fuel sources for heating, right? So if you're saying, well, my all-in electric bill is this and Alabama's is this, well, they don't heat, with electricity in the winter. So you just have to be careful what comparison that you're looking at. That being said, on a per kilowatt hour basis, Connecticut has been, among the most expensive on a per kilowatt hour basis for at least a decade. So at the moment, some of the all-in comparisons that we're seeing do put Connecticut towards the least expensive of the New England states. That's because of the fluctuation in the generation rates that we're seeing since the start of the Ukrainian war. Now, competing for last place is not anywhere that any of us want to be. So again, I think that I'm really actually looking forward to a rate case coming in from one of these utilities, Eversource in particular, because I think that's where you can really get under the hood and ascertain what is being recovered in rates, because the last time they were in for a rate case was 2016, and it resulted in a settlement, a black box settlement. They have not really had their books looked at in over a decade, and I think they really need it.
Okay. So here's a question, and we're just, if we're going to impose on your patience for just one last question, and then we'll let you go. Thank you. But this is on my utility pole, which is in the public right of way. Verizon Fios has left enormous 5-foot loops of fiber optic dangling near my driveway. My property has become a de facto storage facility, and I can't get them to change this unsightly storage. Could I ask PURA for help?
Absolutely. So if the customer did not have a chance to write down our contact information, that is an excellent example of something that's an individual concern, which, to be clear, could be a more rampant concern that needs to be addressed holistically. But for this specific customer, I would suggest calling our call center or emailing at pura.information@ct.gov. And our customer service representative can get them in touch. Well, they will do the legwork with Verizon and seek to have that addressed.
Terrific. Thank you very much. Thank you, everyone, for attending. Thank you for your questions. Thank you, Ms. Gillett, for your time and your excellent presentation and commentary. We really appreciate it. All right. Thank you so much. And we will conclude the session right now. Thank you. Thank you.